Hi, this is Michael Cohen. I'm a Dallas elder law attorney. I'm joined by my good friend Don Crawford Jr., who we did a radio show together for many years, and he's agreed to do a YouTube with me, as we've done like radio shows in the past. Today's topic is on Ladybird deeds. What happens if the grantee, the beneficiary of the property, dies before you? So, what is a Ladybird deed, first of all? A ladybird deed is an enhanced life estate deed. What does that mean? That means that I have this, let's say I have a home, and the home says on the for the home, I say this is my home. I have a right to live there until I die. In fact, it's my home until I die. In fact, I have the right to change my mind. I could sell it, I could mortgage it, I could lease it, I could even change my mind on who my beneficiary is. However, it's considered a transfer subject to divestment. What does that mean? I could, if I had, let's say I had two or three beneficiaries, the what's called the grantee of the property, then if what happens if one of them predeceases you? Well, at that point, the property is what was called vested, at least as the one who died.
Okay.
So if that person died, you can't change them from being a beneficiary in effect. And so what would happen? Well, if the beneficiary had a will, it goes by the terms of their will. If they did not have a will, it goes by heirship laws, the state laws on what happens if you died without a will. So if you had three grantees, let's say you had three children, and you named them all three, but one of them died before you, it doesn't mean that the property all goes to the two survivors. It goes to the two survivors, assuming they haven't died also before, let's say, the parent in this case. But the other third would go to, let's say, the child's children or spouse, depending on whether they have a will or whatever they may have. If it's not a will, it's by laws of intestacy. So uh, so what should you do if you want to not have it go by your child's will or intestacy? Well, you have the deed go to a trust. The deed go to a trust. And you could dictate what happens after, if a child should or whoever the grantee is after you die. Why would you do that? Because the trust could have so much more protections. Like, not only say what happens if child predeceases, on our example, but also if there was three people, well, then there were, if they would have been three people, then, well, what if they don't agree on
Right.
selling or mortgaging or leasing or whatever, or the price? And so by having it go to a trust, you could have one person in charge as opposed to three. And there could be protections. Let's say a beneficiary, one of the beneficiaries is disabled at the time of the parent's death in our example. Or let's say one of them has a credit issue or a marriage problem or has a addiction issue, or so there's lots of different things that could be protected with a trust. If I have something that just goes to some individual, well, it's theirs. What kind of protection do they have? If
Yeah.
they had got sued, it's not their home. A homestead has protection until you die. Uh, but if it's not that person's home, it's not protected. So let's say the child had credit issues. Well, now all of a sudden, at least upon death, all three people, if it went to them outright, the creditor issues could crop up and hurt, selling of the property at a later date. So you could do all sorts of different things. So the preferred method of having a ladybird deed, unless there's just one person, and we hope that nothing ever happens to that one person, would be to have the deed go to a trust because it
Right.
could cover so much more. But and I should also mention, when is a typical uh, ladybird deed used? It could be used for anybody, doesn't, but a lot of people think of it in connection with Medicaid. There's lots of Medicaid programs with all different rules. But you see, even though a homestead doesn't count, if you're single, the equity limit is now 752,000 in year 2026 for long-term care Medicaid. Um, so if your home is worth less than that, the equity limit, so in other words, if there's a mortgage, it could be a home that was 800,000, but if there was a $50,000 mortgage, that still would mean that it's below the limit. If you're single, if you're married, there's no limit. But even though the home doesn't count as a resource to help pay for long-term, if when you apply for long-term care Medicaid, which is means tested, the state may have a right to make a claim against the exempt resource after death. If you have a Ladybird deed, it would avoid a successful claim because the state in Texas only goes after things that go by probate, by will, or by intestacy. Here it would be going by deed. And so therefore, um, uh, it would avoid probate. By the way, a transfer on debt deed is different because remember, on a transfer on debt deed, well, I say remember, a transfer on debt deed is a deed which goes also to somebody upon death, but the one who owns the property, it's theirs until they die. They could cancel the deed, and it doesn't vest. Like I said, on the Ladybird deed, it's a transfer subject to divestment. So they could change it by deeding it themselves, or you can say different things if you wanted to change your mind. But
Right.
on a transfer on debt deed, it's not vested until you pass. Unlike the Ladybird deed, which we said it vested upon if one of the grantees died before the one who was the grantor. So
Right.
it's a lot different. Both of them, by the way, avoid Medicaid estate recovery, and both of them avoid probate. There's lots of different um, pros and cons on each. I have a something on my website, dallaselderlawyer.com. That's dallaselderlawyer.com. If you want to go to any to see about the comparison between Ladybird deeds and transfer on debt deeds, uh, then um, then you could see what's best for you if that's something you like. By the
Yeah,
way,
I don't trust the world, I guess. So I have a Todd or a transfer on death deed for Sarah, and I insist on that because I don't want anybody coming out of the woodworks, out of the blue, and saying, "Where's my money?" You just never know. I know that her Todd is independent of my estate plan. She gets that almost no matter what.
yeah, I mean, but you could cancel it. I
Oh,
mean, God
right,
forbid, not that I know you've been with Sarah many years, but on a transfer on debt deed, it would just go directly to her.
right,
And but you could change your mind. So God forbid the relationship went south all of a sudden, which I know won't occur. But if it ever did occur, then you could always change your mind.
sure.
Uh, Now you couldn't do a transfer on debt deed to your dog Oreo, by the way.
Okay.
Sorry, tell Oreo not to listen to this part. Just we last week we talked about pet trust, but anyway, which he was all ears.
Yeah,
Uh,
right, exactly.
but this time he would not. He's personal property. He's not cannot inherit directly.
I
Uh,
go to the website too, or call you at 214-720-0102, 214-720-0102 for your next workshop too, which I think is in March of 2026. Is that right?
That's right. We had one on February the 7th. We have one every month.
Okay.
And so,
They
you know,
sell out almost, if not completely sell out, which is nice. So that's a good problem to have.
yeah, we have a limited amount of space in our conference center in our building. And yes, the last two have been quote unquote oversold.
Right.
So if you do want to attend that free 2 hour estate planning essentials workshop, as you mentioned, called 214-720-0102, that's 214-720-0102, or sign up online at dallaselderlawyer.com, dallaselderlawyer.com. Any other questions that you have of me, Don?
Nope.
Thank you all for joining.